Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things, Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you are, you're my everything. Say, I call you Jireh. Lord, my provider. I call you Eunice. You are my battle.
It's a lovely Saturday afternoon once again, ladies and gentlemen. Welcome to BWTV, bringing you the community and the law. Now, are you a good boy? Are you a good girl? Are you a good man? Are you a good woman? Are you a good young person? Are you a good young adult? We're going to look at good character assessment in UK naturalization application. We'll be giving you a live example. Apart from that, there are things you need to know as you go in to rent somebody's property and you live in there. What is the responsibility of the landlord and yours as well? What does the law say? My name is Oreku Frimpon and I'm welcoming you to another edition of the Community and the Law live on BWTV Next. Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208-493-7345, or you can send a text 07950-422-780. It's The Community and the Law. My name is Oreku Frimpong, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Well. I know that you're so ready and eager to get onto the journey with us, the community and the law. Once again, my name is Oreku Frimpong, and welcome to another edition of the community and the law, brought to you by BWF Solicitors, our trusted friends when it comes to the law. They are located on the 4th floor of the Honor House, 214 to 218 Tottenham High Road, Seven Sisters, North London, London N15 4NP. You can call them Monday to Friday between 9:30 in the morning and 6 p.m. on 0208 493 7340 0208 493 7340 or the emergency number 077 127 61884. If you're in Ghana, they have an office in Ghana and you can contact them on this telephone number 055 589 59590 55 589 5959. Now, BWF Solicitors is specialist in the law and especially immigration matters, family issues, when it comes to employment and various pieces of advice. You would have to trust BWF Solicitors to give you that. And they also give us the opportunity to learn about new things that happen when they are introduced here in the UK when we talk about the law. This afternoon, I have something so real good to discuss with you. But there's a question that I want to pose. Are you of a good character? How do you assess that? Especially when you're putting in an application for your UK naturalization. We'll be having a live example here on the program. And I am happy to introduce my resource person and guest, a lawyer from BWF Solicitors, Lawyer Charles Asma. And he is going to take us through the various steps in the classroom of the law. So we look at that. So first of all, let's say a welcome to Lawyer Charles Asma. Uncle Charles, good afternoon.
Good afternoon, Rocco.
Thank you for coming.
Pleasure.
It's a lovely Saturday afternoon.
It is.
I am so privileged to have people leave their families and come sit with me here on the program. So thank you so very much and greetings to everybody. How's the week been?
Yes, it's been, as it is always, inspiring the community, empowering the community, and making things happen for our multitudes of patrons, clients, and all those who look up to BWF for one support or the other.
Right.
So I would say it's been one of the great weeks.
Good.
And we're looking forward to another one next week.
Well, and with that, I know we're not doing anything moral here, but we're going to really look at how we can assess what the Home Office terms as good character. And Lawyer Charles Asma will be taking us through that and how we can really navigate around that to help us with our various pieces of application, especially naturalization. But before then, let me update you with something that's happened in the community. BWF Solicitors does that. And we're saying that if you are a tenant living in somebody's home, when a home is unfit for human habitation is what we're looking at. What does the law say? The law says that the landlord must ensure a house they let out is fit for human habitation. The property must be fit for habitation on the day of letting and throughout the tenancy. Where a home is unfit, the landlord must take steps to remedy this. A landlord cannot charge a tenant directly for carrying out the work necessary to make a home fit for habitation. If a landlord fails to ensure a home is fit for habitation, the tenant might be able to 1, take court action, 2, help or get help from the local authority, and or 3, make a complaint to the landlord. Now, this is taken from Section 9A, Landlord and Tenants Act of 1985. What I'm going to do is the senior partner of BWF Solicitors has put out a video. Before I get Uncle Charles to take us through that, he has taken this time to open up the law and then give us a sneak preview into that. But then right after that, I have a couple of questions that I want Uncle Charles to help us answer. So, ladies and gentlemen, watch this.
Hello, today's video is in response to a viral video that has gone around since early this week of a Ghanaian lady in our community who was experiencing serious disrepair in her private accommodation and also moldy conditions, damp, and draft. Unfortunately for her, it's quite a substantial problem which requires technical advice and also repairs by the landlord. Just from the outset, I just want to make it clear that nobody should suffer in silence if you're experiencing serious disrepair in your house that may cause havoc, that may cause hazard, and that may create health issues. We are all aware of the case of Awad Ishaq, who unfortunately died at the tender age of 2 years because the house that he was living in with his parents was full of spores and mold. Obviously, that is a problem that the landlord ought to rectify. Section 9A of the Landlord and Tenant Act of 1985 makes it a duty for the landlord to ensure that any accommodation that they rent out is fit for human habitation. The emphasis is on fit for human habitation. Clearly, the video we all saw this week, the conditions of the private accommodation that the woman is rented, it's clearly not fit for human habitation. And that's a breach of the law under Section 9A of LTA 1985. When that happens, you must ensure that you raise the issue with your landlord, make a formal report or complaint to him, and keep copy of the complaint. If he does not rectify the situation, you will have to raise it with the local authority, the environmental department, who have a duty under the law to either make a recommendation, make a prohibition order, which is that they prevent the landlord from renting the accommodation. So the nuggets that I want to give you today is that everyone who rents accommodation in the private sector is covered both under common law and also by statute. The law says that the accommodation that you rent must be fit for human habitation. So things like cold water, lack of central heating, disrepair under Section 11, things like moldy condition, draft condition, cold houses, unworkable central heating, boilers that are broken down. All this can be hazardous situations which can cause problems for you. Clearly, you're paying for your accommodation, and the least the landlord can do is to make sure that the accommodation is fit for human habitation. So don't suffer in silence. You can also bring a legal action at the county court against the landlord if he refuses or fails to rectify the problems in the house. And as I've explained, this covers a wide spectrum of disrepair. Disrepair itself is covered under Section 11 of the Housing Act. But my specific advice is in relation to Section 9A of the Housing Act, which clearly says every accommodation that is rented out must be fit for human habitation. And clearly, if it's not, the landlord will be breaching the law, both under common law and under statute. I hope this helps you. But if you need more advice, you can contact the Citizens Advice Bureau or the local authority. You can go on the Citizens Advice website, or you can call any of our lawyers who will be able to signpost you to where to get housing disrepair advice. I hope this is helpful to all of you. Please like our video, follow us on TikTok, Instagram, follow us on Facebook and LinkedIn.
Okay, so you've watched that, and I believe that is giving you some insight into it. Now, later on, Pamela will be getting you the quiz, and we'll be asking you a very good question on this very one. So, if you are not paying attention, I want you to really, really pay attention. Let's pick up the nugget again, and I'll go over to Uncle Charles for the explanation. When the law says that a landlord must ensure a house they let out is fit for human habitation. The property must be fit for habitation on the day of letting and throughout the tenancy. When the home is unfit, the landlord must take steps to remedy this. A landlord cannot charge a tenant directly for carrying out the work necessary to make a home fit for habitation. Now, the Section 9A of the Landlords and Tenant Act of 1985 says if a landlord fails to ensure a home is fit for habitation, the tenant must be able to one, take court action, get help from the local authority, or make a complaint to the landlord. Okay, so I'm going to my landlord now to get some explanation. So let's go over to the desk of Uncle Charles and find out. Now, I need a place to live. I found a landlord who has a place for me. He needs to keep it in a shape that I can live in, as the law says. What are some of the things that will make it unfit for habitation, and how do I point that out? If you could help us.
Right. Thank you very much. So viewers and listeners, once again, we've met on this platform. Today's conversation is interesting, both the nugget and the main discussion. For the nugget, it's to do with housing, shelter. We all want to have a well-being. One basic things that everybody wishes for before anything else are shelter, food, and clothing.
Okay.
So when you are taking food,
let me ask a very interesting question. Now, if you say you started with shelter, you went to clothing and food. Is that a new order? Because oftentimes we hear food, clothing, and shelter.
Well, because I suppose because we are saying this in the afternoon. Because the morning would have been different order.
Well, we'd have had breakfast.
Yes. So it doesn't really matter.
Okay.
And this is set out in theory and again in common law.
Okay.
So one thing that everybody wants to promote their well-being through is where they live, and therefore where you live is essential to your well-being, your health, and your total development. So we want to make sure that at least the place is good for human habitation. The word here is human.
Okay.
And therefore the law itself says human. Human habitation means that it should be a place where human beings are supposed to live.
Okay. And
therefore, if it is not fit for human habitation, then it is remote from the common sense approach to deciding whether this is a better or good place. So what are we looking at to say that this is remote from what is normal? If the place is not good for human habitation, it means that possibly the place is infested by rodents and insects and all forms of animals which cannot live with human beings.
Okay.
So we have places where the place is full of mice, and that is not good for human habitation, in that such rodent can infest. Of course, they've infested the place, and the potential
they are poisonous.
Potential harm is contact with your plates, your utensils, and even food. Because you don't know where they walk about within the dwelling. So that's one thing. Again, even if the place is not infested by rodents, we are looking at other natural infestations such as moths. Okay. And we know that moths, if you go into biology, they have bacterial undertone. And therefore, if the place is infested by moths, then that's going to affect your health, and specifically your lung, and your breathing will be affected, and that can affect your life ultimately. So is this a place that a human being should live? The answer will be no, if you have a choice. And we look at the option or the choice. Again, we're looking at the wiring system, the heating system, and anything else that goes to ensure that the place is fit for habitation. If all these things are have been reduced in terms of standard, then we say that there's something that ought to be done. The question is who ought to do that, which ought to be done. Okay. And we are looking at who owns the property. Okay. The person who owns the property is the landowner or landlord. And therefore, the landlord responsibility is enshrined in law under Section 9, capital A of the Landlords and Tenants Act of 1985. Okay. Which says that you, the landlord, because this is for you, make sure that it is good for the person you have given it to. So it's not enough for the landlord to say that, well, I don't have money to repair it. If you don't have money to repair it, you don't give it out. And again, it is not the tenant wish to say that, you know what, if I complain, the landlord may ask me to leave and I may not have a place. Your rights are protected in law.
Okay.
And so, as we have specified, the landlord cannot also charge you for any attempt to repair or put the dwelling into a habitable standard. So if the landlord says, okay, I'm painting or I'm doing this, I'm treating the mold and all these things, the landlord can say, because I've done this, pay for it. Who owns the property? Why should I pay for it? That's the first question.
There's a question on the screen. We have the act, and it says that the property must be fit for habitation. Looking at the second sentence, on the day of letting and throughout the tenants. Now, I live in this property, and through no fault of the landlord, the door lock gets broken, or there's a leakage somewhere through no fault of mine. And then the landlord says, well, you are living in there, so you have to take care of that. Is that what the law is talking against?
No, the law doesn't say that the person who is living at the property should look after the property. Of course, you've got some common law duty to ensure that you continue to keep the place in order. But yours is up to a
certain level. Okay.
The landlord is supposed to ensure that certain things beyond general expectation of the tenant should take care of. So mold, it's not a tenant responsibility to treat molds. But molds tend to be based on the level of humidity within the setting. Sometimes the soil itself can cause these things.
Okay.
But whether it's from the soil or it's from any other point, it's up to the landlord to ensure. But of course, we're also saying that you, the tenant, should not contribute to that.
Okay.
So let's say if every 3 months, with care and diligence by the landlord, attention is given to the walls and other facilities, and every 3 months there's issue, then it is pointed towards the tenant. Then we are saying that you are not being careful and diligent tenant yourself, but you are contributing to that. But where the property itself is no good and it is not the fault of the tenant, then we have to look to the landlord. So the law says that if the landlord is to repair it, they cannot charge the tenant.
Okay.
And if the landlord fails to repair and the tenant does so, the landlord must compensate or must reimburse, either through the rent or through the other means. Now, you don't have to repair and go back and say, pay it back. You have to tell the landlord. So the law says that if you tell the landlord and the landlord fails to act, you can tell the local authority. The local authority is not giving you the support you need. You can go to court, but you have to exhaust all the options. So if you look at the 3 options, you can take court action, you can have a recourse to the local authority for action, but the local authority is supposed to ensure that people within the catchment area have their rights are protected, and especially when it comes to housing, the local authority wants to make sure that landlords are not taking advantage of tenants. So local authority is there. Of course, you can speak to the landlord. If you look at the pecking or the ranking, the order, you can say that rather than going to court, speak to the landlord.
And this is reasonable.
Exactly. So, right, so court, landlord, and complain to the court, local authority, and complain to the landlord. So start from the bottom, go to the landlord, let them know. And if for nothing at all, I can tell them that, you know, the law says that this should not happen in a home where human beings live. And this place is against that. Please fix it. They will, once you point it out to them. If it doesn't happen, you go to the local authority. Local authority will then take action on your behalf.
Right.
If all these are not happening, we have recourse to the law by going to court, so that court will force the landlord to remedy whatever needs to be remedied.
Okay. Now, my other question is, let's take it that I have seen something at the property and I would want that resolved or fixed. I talk to the landlord and then the landlord says, okay, I don't have money at the moment, so you can fix it and we'll have an arrangement. Maybe reduce the amount of money you pay as rent, or we increase the amount of time that you live in the property. Is that allowed under law?
Well, that is not allowed, but I mean, such negotiations do happen. And that's why I said, you see, the law says that directly.
Mm-hmm.
So if you read the nugget, it says that the landlord cannot charge a tenant directly. What does it mean? It means they can, but not directly.
Mm-hmm.
So what it means is that the tenant can take action to repair the damage, not caused by them, but whatever, through any means. Once they have repaired, they have to be reimbursed for the cost.
Mm-hmm.
Or the landlord can say that's fine. It's £800. Your rent is £800 for the month of June, which is about to end. You are not going to pay.
Okay.
So that's an arrangement. Even though the law doesn't say there should be an arrangement, it's a common sense approach to ensuring that both parties are happy. And this is going to help you and also help the landlord. Why not? And a reasonable landlord will be fine. But some landlord may say that, well, you chose to repair it, and therefore you got to pay me my rent. And that's why you don't have to choose to repair unless there is it's gotten to a point where it's obvious that landlord has agreed for you to or consented to whatever you want to. But even that, we've said that complain to them for them to fix it. Go to the local authority or go to court. But the moment you complain to them and you point them to the law, they will rush to fix it because they know that it's against the law.
Would the law be on my side if I say that because X and Y are not repaired, I refuse to pay my rent and I will quit in my own time or leave the property or get myself out of the property in my own time?
Right. So we have the tenancy in one place, and we have anything else that is happening that needs to be dealt with in another place.
Okay.
And therefore, we cannot intertwine the two. Now, your tenancy says that at the end of the month, pay your rent. The tenancy also says that the landlord has the following duties within law and the common law.
Okay.
And so if the landlord has a duty to continuously keep the place in a habitable order, then it is the landlord's duty.
Okay.
Your duty as a tenant is to ensure that the place which has been kept for you in a habitable order is also protected or maintained.
Okay.
But where the maintenance is beyond you, it's up to the landlord. So the landlord cannot say that, you know what, let's have an arrangement, or you the tenant, can say that because I've done this, I'm going to increase the tenancy, the tenure of the tenancy by 1 month or by 6 months. Question is, who consented to that arrangement?
Okay. All right. Then again, in getting the place into a habitable situation, can a potential tenant agree with a landlord to say that I'm going to put my money into changing doors, treating mold, painting up, and it will be factored into my rent? Is that allowed?
A potential tenant?
Yes.
I mean, right? It's like somebody saying that, let me complete the structure
and I live in it.
I live in to offset the cost. I mean, in the UK, these things don't happen often. And therefore, after paying your deposit, you are supposed to pay your rent. If anything is to be done to make the place habitable for you, it is the landlord's duty. And therefore, because we are discussing the legal position of will-be tenants and existing tenants, we will tell you that the law says that if any of these are happening within the home and is making it uninhabitable, you have to report to the landlord, make a complaint. If the landlord doesn't do anything, go to the local authority to tell them what is happening in that home. If nothing happens, go to court, and court will take action under the relevant law. Now, we have, you see, the whole thing is also, as we saw in the video, it's also about the common sense duty.
Okay.
Or the common law duty. I call it common sense because the whole essence of the common law is to make sure that things are done sensibly and reasonably. So it's about fairness.
Okay.
So if you, the landlord, are living in a home that you are enjoying and you've given me this and it's not helping me enough, then that's not fair.
Okay.
Will you, be happy with this dwelling if you were the one renting it? If not, why do you
do that to the other person?
And therefore, common law duty requires that just as it is for any human being, the place is always in good order.
Okay. Well, we're live on BWTV, and the community in the law is bringing you all the updates you need to have when it comes to the law. And we're looking at your relationship with your landlord, where your place of habitation should be in a proper order and situation so you can live comfortably. But remember, you have to pay your rent at all costs. So I'm going to pay my rent and say thank you to BWF Solicitors. And when we come back, we get into some discussion, some teasers, and the rest of it. It's the community and the law.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and thank you for sticking around. Good character assessment in your naturalization application is going to be our focus of discussion later on. But before then, let me say thank you to all of you who have joined us. We're live on BWTV. Naomi Buami is on, and she says, good afternoon. Thank you, Naomi, and thank you for coming on board. Hello, lovely family. That's from Tilly Duma. Next, Tilly says, Margaret Edumensa calling you. Come on board. Ezekiel Johnson, are you there? Tilly is calling you. Kofi Nat backing Mayor 1. Yes, we're looking for you. Are you there, Kofi? Good afternoon, all. Sandra Fraser says, please share when you join. Thank you for your continuous support. Sandra Fraser, thank you for your continuous support as well. We have Rama Nana Sewa, and she says, good evening, everyone. Sandra Fraser, yes, the usual thing, tells us where BWF Solicitors is, gives us all the relevant telephone numbers, 0208-493-7340, the emergency 077-127-61884, and that for Lawyer Eunice 075-3581-3910, Lawyer Charles 079 47636037. Okay, thank you all. And if you come join us, please announce yourself so we see you. Abigail Osemensa, if you're here, please let's see you. And with that, I introduce my co-presenter, Pamela, who is seated right to my left and of course to your right. Pamela, good evening.
Good evening.
How are you doing?
Fine, thank you. How are you doing as
well? I'm good. Well, I'm talking about landlords this afternoon, and it's telling us what the rights of the tenants are, and that's the nugget we have it. Let me quickly have a look at that again. When a home is unfit for human habitation is what we're talking about. Section 9A of the Landlord and Tenants Act of 1985, and it tells us what we need to do. If a landlord fails to ensure a home is fit for habitation, the tenant might be able to one, take court action, get help from the local authority, or make a complaint to the landlord. Well, I know based on that, Pamela has a question for you.
Thank you very much, Oreku. So based on our nuggets, we have our weekly quiz, which I'm going to just preview the question before we actually get into the quiz later on down the line of our program. So the question is, Kofi Brookman has been a secure tenant of Alosman for 2 years and brought a claim against him for disrepair, which included ill-fitting and drafty doors and windows, damp and mold, and a boiler which frequently lost pressure. Brookman complained to the landlord several times over the course of 6 months. The landlord took no remedial action. Brookman wants to sue for damages. Can he sue? So our possible answers are 1. Yes, he can, because it is unlawful to leave a house that is not clean. 2. No, he cannot, because there is a time limit to bring a court action. And 3. Yes, he can, because the landlord has both statutory and common law duties to rent only homes that are fit for human habitation. So this is our question. These are possible answers. We would like to see your answers. We will look at them later down the line in the course of the program, and we will share what the actual answer is. So stay tuned for that. Thank you very much.
Well, and of course, if you are ready, get your answers ready, you can put them in the comment section down below, either on Facebook or on YouTube or on the social media platforms that we have. You can send a text to 0739920848, and that's what we will be asking you. Kofi Brookman and Alosman. We'll see the relationship between them. Well, with that, we are getting ready to get into our discussion, and Lawyer Charles Osman will be leading on the discussion, the good character assessment in our UK naturalization application. Yes, and we welcome back. Good character assessment. How good is your character? And what in the definition of UK immigration law is good character? Now, when we're putting together our naturalization application, what goes into it? We're going to have a live example. And as I said, we're doing this by courtesy of BWF solicitors, and Lawyer Charles Asma is our resource person this afternoon. Naturalization application. Because you do your things like a teacher all the time, I would really want to go to the basics, like Charles Asma. Who is qualified to do a naturalization application?
Right. Thank you. Thank you once again. Hello, viewers and listeners. Today's conversation is very, very important because it touches the heart, the core of our journey to immigration certainty. I call immigration certainty because everyone in the UK, in one way or the other, might have been in the UK as a foreigner and became a national. And that certainty is what we are looking at today, and things that may delay that certainty because of our own character or behavior. Now, naturalization means you want to become a citizen of Great Britain. Being a foreigner and being resident in the UK and having met the residency test, you wish to be considered to become a British citizen. That, in a nutshell, is that.
Right. So I wish to become a British citizen. I believe there are some qualifying things that I will have to really go over before I become qualified. Maybe for purposes of people who may not know, what are the things that I need to do or acquire or attain before I can qualify to become a British citizen?
Thank you very much. So let me draw the distinction in terms of the phraseology, the term. They mean the same thing, but one applies to adults 18 years and above, and the other applies to children under 18. So if you are 18 years and above and wishing to be considered for British nationality, you apply for naturalization.
Okay.
And your application will fall under Section 6 of the British Nationality Act, Schedule 1. Now, if you are a child under 18 years, your application will fall under Section 1, Section 2, Section 3, Section 4, depending on how you are getting into that. But largely, Section 1 of with the relevant subsections of the British Nationality Act, 1981. Now, because today's conversation is not about children, it's about registration, but suffice to say, it's about naturalization, but suffice to say that if you're also a child, there is character assessment that ought to go into your application.
Okay.
So once we get into the character assessment, we're not going to differentiate between young and old. We just generalize it.
Okay.
A human being, a foreigner applying to become a British citizen.
Okay.
Right. So now you're asking what are the criteria for naturalization application. So under Section 6 of the British Nationality Act 1981, the law says that to qualify for nationality consideration, we have to look at criteria under Schedule 1 of that section of the law. So if we look at Schedule 1, it says that a person who has been granted indefinite leave to remain. Of course, there are some little differences. Differences are quite subtle, but for this conversation, we look at the general criteria. The subtlety has to do with people who are British citizens and who have brought in or have invited or who have their families joining them, wives or husbands joining them. Those ones you may not necessarily have to hold indefinite for 1 year.
Okay.
So that is the distinction I want to draw. But for the sake of the wider discussion, I'll just go through the criteria as set out in law.
All right.
So the first one is that you must have indefinite leave to remain for at least 1 year.
Okay.
So you've held your indefinite leave to remain 1 year, barring the differences that may not apply or the exceptions. We are not looking at exceptions, we are looking at the core areas of the criteria.
Okay.
So 1 year indefinite. The second part under Schedule 1 of the law says that you must be somebody who is of good character.
Okay.
So that the Secretary of State will deem you to be someone who is fit to be part of the national community of Britain.
Okay.
The other criterion to consider is your English language proficiency. So the law says that you must be able to have appreciation of English language, which is the main language in Britain. So your ability to, at least to an extent, write, read, speak, and listen to the language and to operate within it. So we're looking at the literacy level and functionality of the individual who wants to become a British citizen. And that's the essence of the English language.
All right.
There is an exception where if the person is 65 years old, they don't have to. And it's the sociological reason for that. Because 65, your assimilation is low. And on a balance, you will struggle to pass exam. And therefore, you are exempted from writing that English language. And again, you must have the understanding or appreciation of the culture, the history, and the general behavior of the people in Britain. And that's what we call the life in the UK test. So you have to sit and pass to be able to be considered. The next one is whether you want to have UK to be your main home. And it's a question of yes or no. If you say no in your application, of course, then you are not ready. So everybody says yes. So that's not a criterion per se, but just a tick box thing.
Okay.
But the other one is your absence. If you have been absent from the UK for a period of time, then it becomes significant in terms of whether you should be considered to have the UK to be your main home.
Okay.
That's a citizenship. So what is the range? Again, there are exceptions for people who are spouses of British citizens. And those ones, with those ones, you don't have to keep it for 5 years, for example. You don't have to keep your indefinite for 1 year. Automatically, once you have your indefinite, you can right away move on to the naturalization application. But for the general ones, you have to wait for 1 year indefinite. The same way in terms of absence in the UK, the general position is that if you have been in the UK for more than 450 days, the law says more than 450 days. It means if yours is 451 within 5 years, up to the date of your application, then that is a criterion that you will not fulfill. So when you are out and about, make sure that in the last 5 years, up to the date of your application, you haven't been absent, unless there was a reason for the absence. If it is a force majeure or act of God, anything like that, then you have no control. But you have to provide evidence that this is what kept me away for more than 450 days in that last 5 years. The next one is that in the last 12 months, up to date of your application, you should not have been absent from the UK for more than 90 days, which is 3 months. So if you are going away and you are planning to apply for your naturalization, you have to consider how long
is it a cumulative 90 days or 90 days at a stretch?
So it says that you don't have to be absent from the UK for more than 90 days in the last 1 year or 12 months up to the date of application. It's cumulative.
Okay.
And therefore, going within that last stretch, last year to your application, make sure that it is no more than 90 days. Again, if there is a reason why you were kept away and the reason is tenable, then could be considered. So it cannot be any flimsy reason. For example, my flight got cancelled. This happened. But if it's to do with your health, then there's nothing you could have done.
So it must be a compelling circumstance.
A very compelling circumstance. Good point. So these are the main. But for the one that we are going to discuss tonight or this afternoon,
is good character.
Good character.
So it is one of the critical points that one would have to consider when you put in an application, even though you need to take all the other boxes. Your good character, because then it's a bit subjective to me that if you ask me what my good character is, I wake up in the morning, I do all the things I do, I pay my taxes, I go to work, come back home, and that's all about it. And that's all I do. How would anything else that I do be considered as not of a good character or a good character? So I believe that you would open the door and let us see what it is and what do we need to look at.
Yes. Thank you very much. Yes. So I think once I mentioned 450 days absence, more than 450 days absence within 5 years, the presumption is that they want to see whether you've been in the UK for 5 years up to the date of your application. And I've got to provide evidence. Evidence of living in the UK. So that's the residence evidence. So just to add to the list. Now, what is good character? Let's have a conversation. What is good character?
To the ordinary person, it means that I don't fall foul of the law. I do what I need to do. I pay my taxes, and I don't disturb anybody. Maybe that's what, to me, would mean a good character. Would I be right?
So to speak, yes. So anything that does not make you go below the standard of the law.
Okay.
So as you said, not falling foul of the law and statute or common law. But
Okay.
there are certain things that might not have been enshrined, but they are expected that we will not be breaching or going against them.
Okay.
Yeah. Now, because we are dealing with policy guidance and we are dealing with things that touches so much the heart of people's journey to citizenship in the UK, we don't want to preempt and guess. So we are going to go by the letter of the law or the guidance book, which the Secretary of State has set out as to what constitutes things that fall foul of good character and what are the things they will consider. After that, we'll look at a live example of somebody who has applied for naturalization or nationality and has been told that the application is rejected on the basis that they have failed good character assessment and what they said and what the person did that has been picked up. Now, in the past, we have talked about suitability criteria under Part 9 of the immigration rules, which deals with a range of things that can be considered to be bad character. Suffice to say that for tonight or this afternoon's conversation, producer will assist us with the guidance book that was issued in 2023, the last quarter of 2023.
Right.
So, nationality, good character requirement, version 4. And this is issued by the Secretary of State, published mid-2023, at the 1st of July. So, just last year. We're not going to go into the content because it's quite a heavy document. So, if you please go up a little, just back up. Yes, back, and yes. Okay, there it says factors to consider. Consider for what?
That will be on page 9 of that.
Yeah, factors. So before you go to the page number, we want to go through the key points. Factors to consider: application of the requirement to young persons. So you realize that we said today's conversation is not about young people applying for registration to become British citizens, but the point of good character cut across gender and age, and therefore there is element to do for children. But this is not children's application, so we move straight to other bits. But it says that criminality. Then there's overview, sentence-based threshold for applications before July 2023. This guidance came in July 2023 to be effective the next day, supposedly, which is 1st of August 2023. What about all those who applied before that date? Will they be assessed based on this guidance? Presumably no. Otherwise it will not be fair. So it doesn't take retrospective effect. So that's why it says that sentence-based threshold for applications made before 31st July. And here we have custodial convictions. So custodial convictions are convictions that leads to prison term. It doesn't matter how many days in prison or hours in prison or weeks and months, custodial convictions. Suspended and concurrent and consecutive sentences. These are keywords. Let's break them down. Suspended. Suspended means that you have been convicted of the offense as charged. However, you are not going to be sent to prison. You are going to be left to go home and rest, with the condition that if you do something else, we'll add the one in the fridge to the one that has come up and punish you together. That's called suspended sentence. Doesn't mean that there's no sentence. Sometimes people say, oh, they said I should just go and do it and not to do it again. It means that you've been sentenced, but it's suspended.
It's sitting there waiting for you.
So it's kept in there for you. Which fridge? The community fridge. All right. Now we move on to the other one, which is concurrent. Concurrent means that you have been charged with multiple offenses, and they are all running
at the same time.
So the conviction or the sentence thereof are running at the same time, and therefore, so that's concurrent. But whether it's concurrent, whether it's suspended or consecutive sentences, it is the case that there is criminality, which will come back to haunt you. Conviction, sentence imposed outside the UK. So you see, that's when you are applying, making this application, they will ask you, have you ever in any country, That is the bit where...
Is that the reason why they ask for police reports when you are making certain applications? From the country from which you are
the police report is for the specific industry that the person applying may be going to work in. Okay. So it's work-based applications, work visas. If the work is the one that requires assessment of character or past behavior, you require police report.
Okay.
Most applications, you don't need police report. And therefore, with naturalization application, you don't need police report. But if there has been offense elsewhere, in other parts of the world, apart from the UK, there will be a question on that. And that's why the guidance, if we go back, producer, crave your indulgence, it says that convictions imposed outside the UK.
Okay.
So the question is, what if I've done it elsewhere? Will that come up? They can pick it up. So that's that way. Convictions and sentences varied on appeal. So sometimes somebody may be sentenced, then it's a criminal offense, convicted, and they will move further on appeal and all this. So depending on how yours is. So each one, some are serious, some are not so serious. In terms of if you are appealing, it means it is not ended yet. Persistent offenders. So if you are a persistent offender, yours is there. Offenses which cause serious harm. Sexual offenses, non-custodial sentences, and out-of-court disposals. So non-custodial sentences are sentences that will not require you to be in prison. Example would be community sentence. Okay. So if you have been sentenced to community work for, let's say, 12 months or whatever, it will be waiting for you when you get to that point. Move down to absolute and conditional discharges. Again, we have fines. Please down. So fines. You've been fined for this or fined for that. So the fines bit are there. Compensation orders, fixed penalties, cautions and warnings. So sometimes when you are applying, they will ask you, have you ever been charged with this? Have you ever had this? Have you ever been cautioned? And So cautions and warnings.
The one on page 18, if you would bear with me. Fixed penalty notices, penalty charge notices, penalty notices for disorder. Now,
so go there, please. Take us to page 18.
Naturally, people get parking tickets that's known as penalty notices, penalty charge notices, and all that. Are they included in this?
So fixed penalty notices, charges notices, and penalty notices for disorder.
Okay.
So here, unruly behavior. This we call it vandalism. So if you are causing vandalism in the community, that is something that is against the public order. So disorder could be unnecessary noise and so many other things. Warned, and it's not working. You are given fixed penalty charge just to serve as deterrent to you. That can come up.
So what if the issue? I'm a persistent offender, and I've been giving several notices, but each time I'm giving, I pay. Will that go against me?
There's somebody who called me, just an example, and said that, lawyer, I've been given this, and I'm asked to report to the magistrate court for questioning or to answer. In that, I've always been drunk and found myself lying on the street. And anytime the police found me, they took me home. And it's been several times. And this time, they are threatening that they will deport me. What do I do? He's already been given a charge note to come to to go to the magistrate court. So that bit ought to be attended to before we come to the immigration side. Because if your behavior is not compatible with a wider behavior, then you don't fit to be part of the community. And that's what we call public interest assessment or test. Okay. So if after carrying out the public interest assessment, yours is incompatible, then you will not be allowed to be part of the public conversation or engagement in terms of your residence in the UK. So it doesn't really matter. Sometimes people are having indefinite leave to remain. I have this. Can that happen to you? Insofar as you remain a foreigner, but this is one that you are seeking to become a British citizen, and this. But even after you have become a British citizen, of course, then you've reached the bar. But there are instances where
it could be taken away from you.
Yeah.
So let's go back to the list and get to the various points of character.
Receiving one of these things does not form part of a person's criminal record. So remember, this will not be on your DBS record. So we won't find it there. A fixed penalty note will not normally result in refusal unless the person has failed to pay or has unsuccessfully challenged the notice and there were subsequent criminal proceedings resulting in a conviction.
Okay.
So like the person I was referring to, persistent offender of public disorder, then it can go against that individual.
Okay.
For example, in the news there was I think over the weekend or last week, a guy who used the word, the unused word on the prime minister, the P word on the prime minister, and the person was called to question to explain himself. His home was searched and they found certain things, and he said that, oh, the text or whatever I was texting online, because he was just chatting on social media, and the police picked it up and they went to question him. He said it was out of fantasy. But they said, well, that is unruly behavior. And they went further, and they realized that he's being charged for similar things in the past.
So it's his character.
So it is his character. Luckily, this person is a British citizen, so it's not a big deal. But if the person were to be a foreigner, that would have affected his ability to cross the line to migration certainty.
Well, moving the discussion on, if we could bring the list back, I think we were on the page where lawyer was looking at the various. Can we go back to the previous one? The table of content, I guess. Yeah, that one. So we're on page 18. But that was a point where we were talking about detention and training orders, confiscation of forfeiture orders, civil orders. What are those?
Right. So community sentences, we've mentioned that you are asked to serve, clean the streets, literally. Community resolutions, there are certain conversations that will be had as to how you are going to live your life within the community because of your character or because of your behavior. Detention and training orders. So detention and training orders will be certain orders that will require you to reform, some sort of reformatory act taken to ensure that. But all these things, what we are saying that some of them will touch, others do not necessarily touch. But scroll down, please, for us. The bit that we want to hold on there for us, hospital or no, considering the balance of probability assessment. So on a balance of probability, the Secretary of State or through the caseworker will assess whether this is a behavior that should be taken serious or not. If it is not something that should be taken serious and doesn't touch the core of the public interest, then that will be disregarded. So whether it will be disregarded or will be considered is on the balance of probabilities. And again, number of offenses. So if we're a habitual offender, that can come into
is there a specific number that if I've offended 5 times, 10 times, 20 times, which would be the threshold?
Well, in terms of offenses, there's no threshold. There is the one is okay. But it says persistent.
Right.
And on a balance, whether such persistent behavior is whatever. Then the seriousness of the offense, very important. So if the offense is that which is serious, will be taken serious as well and will be assessed against you when you are going for your naturalization application. Then the nature of the offense and applicant's age at the date of conviction. So age at the date of conviction is equally important, and the nature of the offense at the date of conviction. You may be a child convicted for murder or manslaughter, for example. It doesn't mean that at the time you were convicted of such offense, you were a child and therefore should be disregarded. That is a serious offense in itself. Again, exceptional and other circumstances that could be considered and other mitigating factors. Please, let's go to the mitigating factors quickly.
That's page 24.
Yeah, mitigating factors. Other mitigating factors. Right. So other mitigating factors you must also consider. And who must consider?
Is the caseworker here?
Caseworker.
Okay.
So caseworker is being told, you, the caseworker, you must always consider whether the applicant has demonstrated genuine, meaningful attempt to change behavior and comply with the law. So that's the mitigating factor. So the example I gave, our friend who called to say that I've been always found on the street drunk. It cannot be sleeping rough as a result of drunkenness, and you are told all the time. It's about, he said, about 4 or 5 times, and they are taking action. Would that be a mitigating factor, or it would be an aggravating factor? It would be an aggravating factor.
Yeah,
it's been a couple of times.
Yeah, and you've been warned several times of that.
Okay. Yeah. An applicant may have also been involved in activities that indicate they may be of good character. For example, they may have. So the person may have their behavior. Over the period, they've been very reformative, supporting the community, engaging in community activities, or you call contributing positively to community. That is a mitigating factor to challenging whatever the caseworker. So the caseworker is required to consider all these things to conclude whether the person's behavior should be regarded or disregarded. Engage with programs or activities aimed at addressing the cause of the offense, such as, but not limited to, treatment aimed at reduction of alcohol consumption. For example, a drug dependency or anger management courses and so on and so forth. And when you see anger management, that means anger can even lead to some people not passing the character assessment for naturalization application if the anger leads to disorder within the community or public.
This brings to mind, I think a few people have asked the question that, well, I have debts that have kind of drowned me, and I have had the opportunity to have a debt management program. I've gone into IVF. I've gone into situations where I'm taking steps to pay. First of all, let me ask, if I am drowned by debt, would that be seen as not a good character?
So there's character debt threshold also here. So producer, please take us to the content page again, so that we scroll down for the bit host is asking about. So that one is, so we have IVA there, individual voluntary assessment for debt. We have bankruptcy, but if we go down, debt. So here we have cautions. So let's be mindful that when you are cautioned, other criminal and suspected criminal activity, please go down to debt. We are looking for debt. See, again, we have involvement with gangs. So involvement with gangs can also come up. Extremism. Extremism, we always see it on the application, any application at all. Extremist behavior. Public order. Go down for us. Corruption. Interesting, isn't it?
Financial soundness.
Now, financial soundness. So before financial soundness, we saw corruption. Interesting. All right, but so financial soundness, bankruptcy. So, I mean, let me tell you one thing. To qualify to practice law, for example, in the UK, you need to pass financial soundness. If you fail financial soundness, you can't get certificate to practice. Because the presumption is that if you can't handle money, or you cannot be trusted with money, then how can we trust you with other people's assets? But financial soundness, bankruptcy is one. So if you've gone through bankruptcy, which is the extreme, the top of the ladder in terms of financial mediation process, bankruptcy, of course, once you go through bankruptcy, whatever debt you owe will be written off, but it leaves a footprint on your financial decency. And therefore, bankruptcy is one that can go against you. Liquidation. Liquidation is where your asset, you can't pay your debt or your bills. And so we have to look at what you have sell it to pay off your creditors. That's liquidation. It's usually to do with companies. But for example, a company director, and the company has gone through liquidation process, then you have been more or less you have supported that cause. Your job as a director is to ensure that the company doesn't get to that position or situation.
Okay.
Consideration of financial soundness. Now we look at debt.
How much you owe?
How much you owe, and also we have the NHS debt. The bit that often comes up is the NHS debt. But in terms of debt, let's go quickly to debt so that maybe someone will say, how much debt? It says an application will not normally be refused simply because the person is in debt. We are all in debt, including the country.
Because they give us credit cards, so we are in debt.
Exactly. They encourage us to be in debt. Yeah. So it's not a big deal after all.
Okay.
Especially if loan repayments have been made as agreed, and if acceptable, efforts are being made to pay off
accumulated debt.
So, for example, somebody who is being on CCJ, and at the same time they are taking steps to resolve it. They have what we call taking active steps. So that's not a big deal. They have shown responsibility and commitment. But those who haven't shown responsibility and commitment, that's where it becomes dangerous. Then NHS debt. NHS debt, the threshold, this one is set out, £500. So it says that where a foreign national has an NHS debt of more than £500, this is grounds for character assessment. And that will call for refusal. So when you are applying, they will ask you, do you have blah, 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 and you have to say. Now, advice. If ever NHS has written to you to say that you delivered your baby at the time that you were not supposed to have it for free, this is your bill. Don't ignore. Call them, arrange. Even if you're going to pay £1 or £10 a month, it's better. When you're applying and you are explaining the situation, you say that I owe £10,000 NHS debt for this and that. I have an agreement in place to pay on installment basis. Are you taking active steps? Yes. So that is better. Now, we have mentioned that where a foreign national, so again, part 9, I think we've already covered part 9. So these are the bits that we want to draw attention to. Debt, but debt to do with NHS or tax office, HMRC, or the local authority, parking fines that have accumulated, offense, driving offense, anything to do with government or the public agency. Is very important you take action if it is a bill that you need to pay. So bankruptcy, liquidation, IVA do not usually form part of the character assessment because I want an IVA, individual voluntary assessment, where you owe so much, different people, and you say that the debt is swallowing you up, and so you want to formalize the debt management process. We call it consolidation of debt. So once you consolidate your debt, a third-party debt consolidator has come in, put all your debt together, identified all the creditors, and they are taking money from you and share to the creditors every month with a view to settling it. How long will it take you? It can take you a lifetime. But are you taking active steps to address it? Yes. And should that be taken as a behavior against you? No. So you see that IVA is not on this one. Right. Now, so the criminal bit, I think we've covered all that.
Okay.
If you permit me, we'll look at how this play out within the proper immigration application.
Yes. So whilst we're doing that, let's bear in mind that you can send in your questions or concerns to our text and WhatsApp number 07399208468, or you can keep send your questions to the comment section down below on Facebook, YouTube, and LinkedIn. We will be, as Laura mentioned, we will be taking a live case and we'll be looking at how it plays out, and of course how you can address some of these things. So we will be looking at an application, we'll be looking at how we go about it, and it's all being done by courtesy of BWF Solicitors on the program, The Community and the Law. We'll be back right after this.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and we still live on the program, The Community and the Law. This afternoon, we're looking at character assessment, good character assessment, I should say, in your UK naturalization application. We're doing this courtesy BWF Solicitors. We want to say thank you to them for their kind support and sponsorship, and also giving us the opportunity to learn about so many things in the community. Call them on 0208 493 7340. This afternoon, our resource person is Lawyer Charles Asma, solicitor at BWF Solicitors. He's taking us through the bits that we need to look at when we're looking at the issue of good character assessment. You can call Lawyer Charles Asma directly on 07947 63 60 37. 07947 63 60 37. He always says that is the line of hope. So call him and you will definitely have that hope the BWF solicitors and the individual lawyers give. Now, a live example we're going to look at. But remember, you can give us a call on the number 0208 493 7345. 0208 493 7345. Or send a text to 077 073. Can you put that number on the screen again for me? Sorry, I missed it. Sorry. 07399208468. 07399208468. Let me stop talking. You have the right stuff. Let's look at how we go about this.
All right. Thank you very much. Yeah. So, producer, kindly permit me take us to the content again. Because what we're going to talk about is linked to that. So go to 39, please. 39 is there, yes. So we've gone past that. So now there's notoriety, extreme behavior, but that's not a big thing. Deception and dishonesty. Part 9, immigration rules. So sometimes somebody will be refused, and they say you've been refused and banned. So if that comes up, it's something that can be, so again, deception and dishonesty, deceitful and the dishonest dealings with Her Majesty's government. So anything with the government, if you've been found to be deceitful or dishonest, failure to disclose information required to a nationality application. So you are now going to apply and you fail to disclose information. That can also come to haunt you. Example could be that somebody who sought asylum, at the time they said that they are called manganese, and now they are going through the process, they are going for naturalization, and they are now called bauxite. When did the change come? So this has come up before somebody's application. It became a very, very complex thing. And on that basis, they were going to cancel whatever the person had been given, even the indefinite, and we had to deal with. Producer, if you go down a little, please. The next one is deportation. Yeah. So deportation order, immigration-related issues. So we have deportation order, sham marriage, abuse of English language or life in the UK test.
How does one abuse that?
That means cheating or getting it falsely.
Okay.
Yeah, and somebody wrote it for you and it's been found out, or you got it by buying or by whatever means. So that's another thing.
Okay.
So, yeah. Failing to pay litigation cost. So this is where you owe the government. That has come out before. You go to court and you are asked to pay the government cost for losing the case, and you fail to do so. That can come up against you. So all this overstaying, illegal entry, absconding, and all that. So please, let's go to the example for the live example. Right. Okay. So this is a live example. 24th of June 2024. The person receives this letter from the Home Office. Producer, please take us through the content of the letter. Dear XYZ, I refer to your letter dated in which you have requested that we reconsider your client's application for British citizenship. So the person's application was refused, and we challenged them to reconsider on the basis that what they cited shouldn't have been the case. Okay. And this is the response to our challenge. Your client application was considered under 6.1, which we have already cited, naturalization. Citizenship and the means by which it may be acquired is defined in the British Nationality Act and the regulations made under it. The policy on which working practice in the Home Office is based is set out in the nationality staff instructions, which are available at this. One of them is what we have shown. And applications are decided by reference to this guidance, the one we saw. Naturalization and registration decisions can only be reversed where it is clear that the original decision was not taken in line with the policy and nationality law at the time the decision was reached. The applicant must demonstrate that they've satisfied the statutory requirements. One of the requirements for citizenship is that the applicant is of good character. Good character is not defined in the law, which is the nationality law, but the applicant is expected to have shown due regard for the laws of the country which they wish to become citizen of. At the date of your client's application, now the context. At the date of your client's application, decision, so it says, at the date of your client's decision, in exceptional circumstances, we would disregard a recent conviction. You see, so there are some convictions could be disregarded. Okay. We would have ideally or ordinarily disregarded recent conviction for a single minor offense. But normally, we would not grant citizenship to a person who had been, and this is the checklist. 1, sentenced to a period of imprisonment of 4 years or more, or sentenced to a period between 12 months and 4 years, and sentenced to less than 12 months imprisonment unless 10 years have passed since that sentence.
The end of the sentence. Okay.
So these are the serious ones.
Okay.
So if yours is one of the serious ones, it will trigger rejection or refusal. If yours is one of the minor ones, it may be disregarded. Now let's move on. What happened? What did they say? Right. Last one is convicted of a non-custodial offense or cautioned in the last 3 years. So how long should it be? If it is one of the usual ones, 3 years is important. But if it is serious offense, it doesn't really matter how long. Now, your client was convicted of possession with intent to supply Class B drug, cannabis, 30th of October 2012. You see?
That was way back.
Way back. More than 10 years. Because this is 2024 letter. They are referring to something that happened in 2012. That's about 12 years ago, right? At the date of your client decision, the form AN guidance confirmed that AN is a naturalization application. If you are convicted and sentenced to a period of imprisonment of less than 12 months, applications will normally be refused unless 10 years have passed. You challenge the Secretary of State decision to refuse your client application on the basis of compassionate circumstances. So we were arguing on the basis of compassionate circumstances, that they are sick, they are this, they are that, and therefore asking them or removing them will be harsh. Then they said that we said all this. He made a genuine mistake. So here it says that you challenge the Secretary of State's decision to refuse your client's application on the basis of compassionate circumstances.
He made a genuine mistake. He's extremely remorseful. If he could go back in time, he would not get himself involved in such activities. He regrets his actions. He has not been involved since. He's a family man, as a father, a husband. He has been employed as a delivery driver for 10 years. 10 years has passed since the end of his sentence. He was awarded a bravery award certificate by Thames Valley Police for assisting an unwell woman.
These are mitigating factors we are citing.
We're citing, okay.
Here.
Then you continue to say that there are a number of factors that were considered during the application process to ascertain and evaluate whether or not the good character requirement for naturalization can be met.
On this particular occasion, what happens?
It is apparent that your client, convicted of possession with intent to supply Class B drugs as cannabis on the 30th of October 2012 and sentenced to 20 weeks imprisonment on the 7th of January 2013 at Buckinghamshire Magistrate Court. This adverse factor therefore detracted from his overall capacity to meet the good character requirement for naturalization and resulted in his citizenship application being refused. Having taken all those factors into account, the Secretary of State has concluded that your client is not to be considered a person of good character for the purposes of nationality casework guidance, and that these are not compelling reasons justifying departure from the guidance. That is because, in his view, the factors in your client's favor do not adequately mitigate his disregard of UK law. I wasn't going to ask a question like that. The circumstances, when we're looking at the criteria, there was the point where it says that you may have followed some programs to help you reform. These circumstances, he's a father, he's driven for a company for 10 years, he's been given an award. Obviously, it shows that over time, he has had something to show as a positive something for us to consider. But there's no guaranteed or properly official and properly put together program that shows that he's gone through these reforms and has been certified. Would that be the reason why they were looking at it from that angle and saying that, well, it doesn't show he's reformed?
Not necessarily. Not necessarily. So the caseworker in this particular instance is just sticking to the rule book, which says that if somebody has been convicted and sentenced of a serious offense, this should be the punishment. And so the person is not of good character, in that the innate behavior may still be there or may still be there. But is it reasonable? That's a different question. So the caseworker has done what they have to do, but as to whether this person can win and eventually be granted, depends on what he does or she does.
Okay.
And again, this is a decision by a public authority or agent, Secretary of State. So the best course will be judicial review for the court to ascertain or determine whether, on a balance, the decision taken to disregard the reformation of this person's character is reasonable, rational, or lawful. It is lawful because the law says you must be refused. But is it rational, reasonable, on the basis of the Wensbury reasonableness test? And again, on the basis of common law, and again, on the basis of what actually should be done to somebody who has family, who has this, who has that, the mitigations. Then another court will have to make that determination. But the essence of this is for people to be aware that doesn't really matter how long.
How long, yeah.
It can come out.
So in this case, does the condition of that person, the application is put in, the refusal has come through, the reasons have been cited, you go through the guidance, all these things do not qualify him. Is that the end of the story, or it could be appealed after going through courts for judicial review?
So that's not the end of the road for our case or scenario subject, in that this is a decision by the Secretary of State. Under public law or constitutional law, if a public officer makes a mistake or takes irrational or unreasonable step, as in this instance, the best place would be to go to court, for the court to review the decision and to make a determination whether it should stay or should be reversed.
Right. And then finally, if I'm granted the naturalization, would they want to follow up to see if really and truly I followed the program and have reformed? Or once they grant it, well,
once you're granted, if I reach your immigration certainty, haven't you? That's what you are seeking.
Yeah.
Yeah. So, and that is why they want to make sure that all those who are able to go through the net are properly screened.
Is this a difficult threshold to meet?
Well, you can see that it's not difficult, but depending on how we conduct ourselves, it might be challenging. And you need then have to look at what can be done so that you can remain. In this case, this person has indefinite leave to remain. They are not taking the indefinite leave to remain away.
But you can naturalize to become a citizen.
Yeah. For whatever happened after the conviction, almost 12 years ago, he still survived in the UK.
Okay.
And it's gotten to the point where he's being referred that 12 years ago, this will happen, and therefore we don't think you are good enough.
Well, we will be taking your concerns and your questions, and also get Charles Asma to answer them. The lines are 0208-493-7345. You can send a text to our text and WhatsApp number 07399208468, or you can leave that comment in the comment section below. First off, in any case, just remember that very soon we'll be bringing you the quiz segment as well. What is the current application fee for naturalization? That's what somebody is asking. Nanetri is asking that question, last man.
Right. We all thought that it was 1,580, but just yesterday I submitted somebody's naturalization, and I was surprised to see that it's gone up, and it is now £1,630.
£1,630
yes,
for the naturalization application.
Yes.
Would it be the same fee for indefinite leave to remain?
No, indefinite is £2,885.
Plus the NHS?
No, that is
included.
So once you are going for indefinite, you are automatically going to be considered for free NHS service. So you don't pay NHS. I think that is why they have included, so that they've boxed it up to 2,885. Without telling you that there's
just in there. Well, get your questions and concerns coming through. Now, there was this scenario. Okay, yeah, let's pick up Muftao's question. My question is, can one apply for emergency travel permit waiting for your indefinite leave to remain?
I mean, if you are going for indefinite leave to remain, it means your standard leave to remain has expired and you want the final one.
Mm-hmm.
At this point, the leave you have is expired, so you don't have anything.
Okay.
The fact that you are going for indefinite doesn't mean that you have something, because you operated, you are protected under 3C, Section 3C of the 1971 Act. However, at this point, you don't have anything. So if you leave the UK for your holiday, how will you come back? What is the emergency permit for? To attend to funeral or to do what? And therefore, it's a choice for the individual.
Mm-hmm.
So once your application is pending, once you withdraw or you take your passport, application is considered withdrawn. And the consequence will be that if you don't have any leave, you don't have any leave. So you can't come back. Question is clear. Can I go for emergency travel? No, you can't go for emergency travel.
Because it means that technically at that time you don't have any leave.
Yes.
So until you are granted your indefinite leave to remain, you don't have to risk it.
You don't have to risk it.
Okay. All right. So yeah, keep your questions coming through, as I said, in the comment section below, or via text 0739920846. You can call us in the studio 0208-493-7340. Somebody called me yesterday and asked this question. I said I'll put it across that he's put in an application for indefinite leave to remain, and he had a call from an anonymous number. Mm-hmm. And the person was saying that you put in an application for indefinite leave to remain. You indicated that you've done your English language test and the reference you're giving is not correct. So give me the correct reference number so that I can proceed with and progress your application. Now, he felt that it could have been anybody else trying to get information off him. So he refused to give that information and asked them to write an email, which they did. His concern is that going to delay the decision on his application?
What is going to delay? Is it the email that they sent?
That
he told them to send the email.
He told them to send the email. So his concern is
like challenging them.
The person was making a decision at the time that he wanted the further information. So if he had not, once he did not give it, it means that he's going to go back to the bottom of the queue or something.
But the thing is, I mean, sometimes I tell people, if you have a choice, you choose what is okay for you.
Mm-hmm.
If you don't have a choice, you don't really have to fight a losing battle anyway. Waste of time. So I tell people, I mean, what can you do about it? If you already told the person that, can you send me an email so that I know that I'm dealing with you, and also to have something on record.
Okay.
They have agreed. Hand the phone. What the number is not even a number that you can call back, but it's private number issue. So how do you know who even called to call back to say, please, this is the number?
Yeah.
Whatever it is, you have to respond to the email. Whether it's going to delay or it's not going to delay, the answer to the question is not going to change anything.
Okay.
And I would say that don't worry about whether it's going to delay or not.
Well, obviously, he's got the feeling that once somebody has come up with that, it was close to a decision and it may delay. In any case.
But for example, if a lawyer says that it won't delay, what is it won't delay? How do you define it won't delay? Does it mean it will come the next day or to come 1 year later?
You wouldn't know.
What is delay and what is not delay? It's not defined quantitatively. And so, my brother, don't worry, it will come.
Well, we have Protocol Kwame Safo's question. And he says that when you do childbirth registration at the council and place of birth of both parents, you made it in Ghana, whilst the place of birth on your passport and BRP is Accra. Is it a problem, or does it need to be changed on the birth certificate to be the same as on the parents' passport? When you do childbirth registration at the council,
yes,
and the place of birth for both parents is Ghana, whilst the place of birth on your passport and BRP is Accra. Well, Accra is in Ghana, I guess. Is it a problem, or does it need to be changed on the birth certificate to be the same as on the parents' passport?
I mean, the reason why I'm struggling to understand this is that the child registration or the birth certificate of the child is mother, father. I don't think they put the parent's place of birth and date of birth there. It's usually the child, date, place of birth, gender, parents, father name, mother name, and so on and so forth. That's what I know. Our brother, if you want to call us to clarify this, but I don't think it's something. Maybe we don't understand the question, or
well,
maybe
probably.
there's something missing.
Well,
but
if you can give us further information, that would be very much appreciated, so we can give you a proper answer. And then, when your questions come, people kind of compare to their situations, and if the correct answer is not given, it may also get them to get the wrong impression here or there. Dream Chaser. It was one given to, if one was given 2.5 years through a British child on the parent 10-year route, and he tried switching to 5 years, then he was put back on the 10-year route after submitting all the required documents. And when he was going for the third renewal, Home Office put the person on 5 years route automatically. What can be the reason? What should the person do in this situation, lawyer?
I think we answered Dream Chaser on Friday. Yes, it's one of the questions. Excuse me, that came up, and I recall answering. However, we're going to reiterate the response. So this is somebody who has done 2.5, another 2.5, and a third 2.5. Now, I always tell people that the moment you finish the second 2.5, it doesn't really matter whether you are under 10-year route or 5-year route, because the savings you are seeking to have is not going to happen. The 5-year route, once you are put on that, you have to do 2.5 twice. 10-year route, you have to do 4 times, which is 10. So if you've already done 2 on the 10, and you are doing 1 under the 5, 7.5 years. After that, you have to complete the 5-year journey. So it's not like you've done 2 there, you've done 1 here, so you've already done enough, and so you go for indefinite leave to remain. Once you switch to the 5-year route, I always call it the train and the bus. 10-year route is the bus. 5-year is the train. Once you jump off the bus to join the train because you think it's quicker, depending on how long you've traveled, it may not make any difference. If you have only 1 stop to reach your destination and you jump to join the train is going to take you there. But they won't say that because you've already traveled on the bus, this train is not going to move. Only you will be catapulted to the destination automatically. It won't happen. So if you come to the 5-year route, you stay there 2 years. You've already done 5 years, you are doing more 7.5. So my brother, the reason is that the time you were put back on the 10-year route, even though you are applied under 5, you are living with the child and the mother as a family unit under Gen 3.2 of the immigration rules. And once you do that, even if you switch, you still be put back. And when you were going for the third one, at that point, for whatever reason, you were living alone, and the baby and the mother were living elsewhere. So at that point, you qualify to be put under 5-year route. It doesn't really make a difference. You should have stayed where you were. How long will it take you? You've done 7.5, you need 2.5 to go to be able to have the 10 years for indefinite.
Well, at this point, I would want us to quickly turn around and come back, and that will be Pamela's Corner, the question. But before then, let me give you the benefit of our nugget that will help you go through whatever the right answer you think is. When a home is unfit for human habitation, the law says that a landlord must ensure a house they let out is fit for human habitation. The property must be fit for habitation on the day of letting and throughout the tenancy. Where a home is unfit, the landlord must take steps to remedy this. A landlord cannot change a tenant A landlord cannot charge a tenant directly for carrying out the work necessary to make a home fit for habitation. If a landlord fails to ensure a home is fit for habitation, the tenant might be able to 1. Take court action, 2, get help from the local authority. And 3, make a complaint to the landlord. Quoted from Section 9A, Landlord and Tenants Act 1985. It's the community and the law, and we test your brains next.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back to the program. We have finally reached our quiz section, a segment of the program. So I'm going to go through the question once again and see the answers you have given us, and then we'll finally take it to Lawyer Asma to have a discussion with it about the question and for him to give us the right answer. So the question once again is, Kofi Brockman has been a secure tenant of Alosman for 2 years and brought a claim against him for disrepair, which included ill-fitting and drafty doors and windows, damp and mold, and a boiler which frequently lost pressure. Brockman complained to the landlord several times over the course of 6 months. The landlord took no remedial action. Brockman wants to sue for damages. Can he sue? The first option is yes, he can, because it is unlawful to leave a house that is not clean. 2, no, he cannot, because there is a time limit to bring a court action. And 3, yes, he can, because the landlord has both statutory and common law duties to rent only homes that are fit for human habitation. So we are going to look at some of the answers you have provided to the question. We have Charles Emery, who says the answer is number 3. Yes, he can, because the landlord has both statutory and common law duties to rent only homes that are fit for human habitation. We also have Robert Janefy, who says the answer is number 3. Then we have got Susanna Adams, who also agrees that the answer is number 3. We have Mark Intim, who has decided to differ from everybody else. He says the answer is number 2. No, he cannot, because there's a time limit to bring a court action. We also have somebody with a very different answer. Emilia Boating says it's number 1. Yes, he can, because it is unlawful to leave a house that is not clean. So we are having all three answers everybody thinks is something different. We have Angela Kusi, who also believes it's number 1. We have Samuel Ojuro Ansa, who says the answer is number 3. So we have a lot of different answers, but it's time for us to ask Lawyer Asma to go through us. Then we'll find out which answer is the correct answer. Lawyer Asma, can you kindly take us through?
Yes, I can. So, well done to everyone who participated in this quiz segment. Your answers are well appreciated. If this was a vote of confidence, would have given the vote to the majority. So majority ordinarily would have won. So let's see if the majority actually won. So we have 2 yeses. No is out. So let's look at the first yes. The first yes, the reason for the yes is that you can't live in a house that is not clean, but you chose to live in a house that is not clean. So that is not the yes we are looking for. We are looking for the other yes, which says that there is a law that forces the landlords to ensure that the house is clean for the tenant to be able to have a meaningful habitation. And therefore, the third yes is the yes we're looking for. Answer is 3.
Okay, thank you very much, Lawyer Asma. So as we have it, the answer is 3. A rented home is unfit for habitation when conditions or safety issues are so bad that it is not reasonable for you to live there. Landlords must make sure your home is fit to live throughout your tenancy. If you are unable to resolve the matter with your landlord, you should report the issues to Council's environmental health team. As a last resort, you can sue the landlord. The court could order your landlord to carry out any work needed and pay your compensation. This is from Section 9A of the Landlord and Tenants Act 1985. So thank you all for your answers to the quiz. The answer is number 3. Congratulations to everybody who chose number 3. You were right.
Well, I think that it was a tricky one. I would have gotten it wrong anyway. So, those who wrote number 3, congratulations to you. Same time next week, Pamela will be bringing you another question. I know since she started writing the questions, they've been quite tricky and difficult. But in any case, that's what it is. Thank you, Pamela. Thank you for everybody's participation. Lawyer Asma, tradition cannot be broken. Can we have a summary of what we discussed?
Sure, we can. Yes, so hello viewers and listeners once again. Thank you for keeping faith with us. We've gotten to a point where we sum up. And what have we learned? Good character assessment in UK naturalization application, a live example. So today we've taken you through a live example where somebody applied for naturalization, the person was refused, and a lawyer was requested, or the person sought lawyer to challenge the decision, and a response from the Home Office revealed something that I'm sure the person had even forgotten, in that the person in October 2012 was charged with possession of Class B drug and eventually convicted of an offense and sentenced to prison or custodial term of 12 months, give and take, under or over. Now, the Secretary of State says that because the person was convicted of this offense, the person's behavior is against the public good. Whether there has been lapse of time or not, it is not the point. So we've taken you through the various offenses within the guidance published on the 31st of July 2023, set out offenses that can lead your naturalization application to be refused. And we have understood that it is important to be careful as we lead lives or live our lives in the UK, because whatever we do will come back. However, if for whatever reason something has happened to you in the course of your life in the UK, the Secretary of State will look at whether the behavior is something serious, or the offense is serious, or the offense is something that is trivial, whether there has been mitigating factor or no mitigating factor. In this case, even though there were mitigating factors, the Secretary of State did not agree. And what should this person do? So if you have also found yourself in this situation, we will tell you to go for judicial review of this decision, where upper tribunal will sit on the matter and make a determination as to whether this decision is rational, reasonable, even though lawful. Is it still rational and reasonable? If it is determined that it's not rational, then it will be reversed so that it can be granted naturalization as you seek. Thank you for your time.
Thank you very much, and it's been a pleasure having you around. I know definitely there was a lot of information that we needed to look at, but if you need any further clarification, as we have always said, contact BWF Solicitors on 0208 493 7340. 0208 493 7340. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. They're on the fourth floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London. If you're driving, the postcode is N15 4NP. And by that kind courtesy, we have brought you another edition of The Community and the Law. Lawyer Charles Asma, thank you very much for your time. And to everybody that's been part of the production, the lawyers and all the staff of BWF Solicitors here in the UK and back in Accra, and to my co-host Pamela for that wonderful presentation and also that interesting quiz. She'll be back again with it same time next week. To Padma Dodu and Sheila Ankra for the admin and the aesthetics work, and to my producer, Professor Ade, for getting us to come your way live on BWTV. My name is Uriku Frimpon. Good evening.